trickle in to start the speeches, but I'm going to give the quick introduction of this event. Thank you all for coming to this Rice Federalist Society event, Big Tech, Section 230 in the Social Media Age. I'm Dylan Glenn, co-president of the Rice Federalist Society chapter, and I will be moderating this event today. We have gathered an incredibly qualified panel of experts to provide their take on current issues in online content moderation and regulation. I would like to thank Rice Federalist Society officer team, especially my co-president, Jacob Koelsch, and our external vice president, David Getter, for getting these speakers here today. Our topic today is, of course, Section 230 of the Communications Decency Act of 1996. This federal law states that online services cannot be treated as publishers of content posted by third parties. Further, it grants web services broad freedom to moderate their content in good faith. Section 230 has sustained attack since its inception, but the policy came to the national forefront following the Capitol riots of January 6th and the subsequent removal of former President Trump from Twitter. Since then, President Trump has called for a partial repeal of Section 230, arguing that social media companies went too far in their moderation practices. Many prominent Democrats have also suggested a partial repeal of Section 230, arguing that social media companies did not go far enough in stopping the spread of misinformation that led to the Capitol attack. With this relatively obscure internet policy now brought to national attention and brought under attack by both sides of the political aisle, we have gathered this expert panel to help us understand the issues at hand and break it down for us. I would now like to introduce our speakers today. I'd first like to introduce Josh Blackman. Professor Blackman is a national thought leader on constitutional law and the United States Supreme Court. Josh's work was quoted during 2 presidential impeachment trials. It's a good fun fact. Josh regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and other leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law in Houston. He's also an adjunct professor at the Cato Institute. Josh has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. Now I'd like to introduce Baron Soka. Baron Soka is the president of Tech Freedom, a think tank dedicated to issues of internet freedom and technological progress in our changing world. Previously, Mr. Soka was the director of the Center for Internet Freedom at the Progress and Freedom Foundation. He was an associate in the communications practice group at the Latham & Watkins law firm, where he advised clients on regulations affecting the internet and telecommunications industries. Very grateful to have him. And last but not least, we have Megan Brown, who is partner at the Wiley Ryan law firm in Washington, D.C., holding expertise in a variety of statutes, including the Federal Trade Commission Act, Federal Communications Act, and state consumer protection and cybersecurity laws. Ms. Brown serves on the U.S. Chamber of Commerce's Cybersecurity Leadership Council and is Associate Director for Cybersecurity at George Mason Law School's National Security Institute. She is also a former Senior Department of Justice official in the George W. Bush administration. We'd like to again thank all of our speakers for coming here today to provide their valuable insight on this topic. So the way this event will be structured is each speaker will have 15 minutes to make an individual remark. After their speeches, we will enter into a question and response period, including questions from you in the audience. Without further ado, the order will be first Professor Blackman, then Mr. Soka, and then Ms. Brown. Professor Blackman, you have the floor.
Thank you so much. I'm actually in Houston, believe it or not. I teach at South Texas, which in theory is about 5 minutes from your university. I haven't been there in a year, but it's a building in town. Eventually, when we're all back to normal, you're all welcome to come visit my law school classroom anytime you want. Please just send Dylan an email. He can put you in touch with me. Our topic today is a timely one. It's Section 230 of the Communications Decency Act. But to understand 230, we need to give you a little bit of a background, and that's what I want to do here. So first off, there's something called defamation, which you may have heard of, maybe you haven't. Usually we have free speech, right? I can express my opinion and say that Megan is an awful lawyer, terrible lawyer. She's not, she's a good lawyer. And then Baron doesn't know what the hell he's talking about with tech. He really does. He knows what he's talking about, right? But these are my opinions. But if I were to say that Megan is a felon, she's a criminal, and I said that Baron cheated on his taxes and defrauded the United States government, right? Those are statements of fact, which are false. I think they're false, right, guys? They're false? I think they're false. If I were to say those things, then Megan or Barron could sue me for what's called defamation, also called libel or slander, depending how I say it. The laws of libel and defamation are pretty strict, right? You need to show there was a false statement that injured someone's character. Okay. Now, what happens if instead of I say that statement out loud, I were to publish it in a newspaper, right? I take out a full-page ad in Houston Chronicle saying that Megan's a felon and Barron's a fraudster, right? Could you sue the Houston Chronicle for defamation? And there's a long line of cases on this issue. What if I were to instead publish a book in which in the book I said that Megan was a felon and Barron was a fraudster, right? You could always sue me, the author, for defamation, but can you sue the publisher? And the short answer is, yeah, you can probably sue the publisher. Now, these are perhaps public figures, makes it a little bit tougher, but the publisher, right? The publisher of information is often going to be on the hook for potential defamation suits. Now, what if instead of me publishing this information in a newspaper or a book, I went down to a bulletin board, those things on campus where you put a little push pin in the wall, if you still have those things anymore, where you put a little push pin in the wall and you put a piece of paper up, right? What if I would just go to a random bulletin that no one really monitors and I just put on a piece of paper on the wall that said, Megan is a felon and Barron's a fraudster, right? Could I then sue Rice University for hosting this bulletin board where there was defamation? Probably not. Rice wasn't really, monitoring this board. They didn't know I put it up there, right? It was just sort of an open forum, right? They weren't using any sort of discretion to pick and choose what goes on this wall. All right. That background should make this discussion a little bit more useful. There's a difference in the law today, at least, between publishers and platforms. There are some entities that publish information that actually use judgment and use discretion over what to include and what not to. And then there are platforms, which is more like the bulletin board, right? And the bulletin board is just you stick on whatever you want, and they're not really deciding. All right. So now let's give a brief history of the internet, which was before all of you were born. There used to be something called CompuServe. You may have heard of America Online, perhaps. Around the same time, there was a service called CompuServe. Actually, AOL bought CompuServe. And CompuServe had what were called bulletin boards, which are exactly how they describe it, these online places where you could post information, right? CompuServe didn't monitor these bulletin boards. They were simply open. And anyone with a CompuServe account could post information to these bulletin boards. In the early 1990s, a person put a message on one of these bulletin boards that was considered libelous, that is defamatory. And that person sued CompuServe for hosting this defamatory content on their service. And this was a case, very famous case called Cubby, C-U-B-B-Y, Cubby versus CompuServe from 1991. And this came from a federal court in Manhattan, New York. The judge ruled in favor of CompuServe. And they said that CompuServe did not have editorial content over this defamation, right? The court said that CompuServe was no different than, a bookstore. Those used to exist, I think, or a public library. And then the judge made, I think, a fair policy argument. He said, if we hold CompuServe liable, it will put a burden on the free flow of information, right? Because if you have liability, right, if you can sue CompuServe for defamation, then CompuServe may say, you know what, we're not going to host a bulletin board, right? It's not worth our time to go through the comment section on this bulletin board to make sure everything's kosher. Let's just shut it down and we won't have this at all, right? So imposing liability, the court said, would actually decrease the amount of speech that is available. All right. But then a couple years later, there's another case, also in New York, but in a New York state court. The name of this case was Stratton Oakmont, Stratton Oakmont. Stratton Oakmont versus Prodigy. Prodigy was a competitor to CompuServe. They were similar services, and Prodigy also hosted a bulletin board. Once again, some anonymous person posts on this Prodigy a message board, and they put allegedly defamatory material. Stratton Oakmont sued Prodigy for $100 million. That is a lot of money. Now, the court could have relied on the CompuServe case, but the judge didn't. He went in a different direction. In this case, Prodigy was actually controlling the message board content, right? It wasn't just letting people post whatever they wanted. Prodigy actually controlled the content. Indeed, Prodigy developed software that would automatically screen what was posted and filter it. And in some cases, they would even remove the content that was posted if it violated the the Prodigy guidelines. Right? The court acknowledged that the CompuServe case was different because CompuServe was just an open forum. There was no filtering. But Prodigy's decision to use this filtering technology and remove content that violated its guidelines made it a different case, right? Stratton Oakmont and the Prodigy case were different. You might say that CompuServe was just a platform, while Prodigy was a publisher, right? Prodigy operated as a moderator. So there's a bit of a dilemma if you think about it. If you do what CompuServe did, then the sites are just hands off and they put whatever content you want on the site. And that could be pretty bad. If you're like Prodigy, you use some filtering, some content moderation, but then you consider it a publisher. So you have this dilemma, right? After the CompuServe and Prodigy cases, if you were a reasonable business, you would say, wait a minute, I don't want to be sued for $100 million. I'm going to follow the CompuServe model. And I'm going to let people post whatever crap they want on my site, or I'm not going to let them post anything. This history led to what we now know as Section 230, this sort of dilemma. And Section 230 creates what's often called a sword and a shield provision, right? A sword and a shield provision, right? A shield is what you defend with, and a sword is what you attack with. So as these sort of two elements. So first, what is the shield element? Let me just read it to you. It says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of information provided by another information content provider. All right. This is basically a repudiation of the Prodigy case, right? It repudiates the Prodigy case. How? In Prodigy, the court said that Prodigy was a publisher of the information because it used content moderation. Here, the law says you will not be a publisher if you host information someone else created. So if you have a message board or some sort of a social media site and someone puts on defamatory material, the social media site will not be considered the publisher, right? Prodigy, CompuServe, okay, those don't exist anymore. Twitter, Facebook, Yelp, whatever site you want to, Instagram, right? Whatever site you want to use, if they're letting other people post their content, they're not publishers. And this also extends to newspapers, the Houston Chronicle, right? Huffington Post, right? If those sites have a comment section on the bottom, which are god awful places to stay out of the comment section, especially on YouTube, it's the worst, right? But those sites are not considered publishers. They're considered interactive computer services, which is what you might call a platform. There's also a sword provision, right, to go on the offensive, right? It says no provider of an interactive computer service should be liable on account of any action taken in good faith to restrict access to certain types of material. So in other words, let's say you post something on Facebook and Facebook thinks it's obscene or harassing. Facebook can delete the material. And you know what? You can't sue Facebook for taking down your post. Oh, now you see where this comes into play, right? The sword provision lets Facebook go on the offensive and preemptively moderate their content, delete stuff to try to avoid potential issues, right? Social media companies can make their own social content policies, and they can take stuff down without fear of being sued, right? Facebook can delete speech even if it's speech that would otherwise be protected by the First Amendment, right? For example, pornography is protected by the First Amendment. Obscenity is not. Maybe you come to my class, we'll draw the line between pornography and obscenity. It's a hard line to draw, but pornography is protected. Still, you can't post porn on Twitter. They'll shut you down. They'll delete your account. All right. That history, I think, brings us to where we are today, my friends. We are now in a place where social media companies have a lot of market clout, a lot of market power. Our president, the president of the United States, had his Twitter account disabled during the middle of a insurrection, right? And in one fell swoop, Twitter prevented Trump from speaking to the masses, right? Trump had to go talk through reporters, which he never did before. A lot of people on both sides of the aisle are unhappy with 230. Conservatives, or at least Republicans, argue that Section 230 is bad because it lets these big tech companies take down conservative social media posts. So there's a movement on the right to kill Section 230. There's also a movement on the left to kill Section 230. Why? Many people think that Twitter and Facebook allow harassment of women, of minorities, of people of color, right? That these are tools used for oppression, and that the United States needs to take a bigger hand to ensure that social media is a safer place to be. We have this weird confluence of overlapping interest groups where people on the right want to kill 230, people on the left want to kill 230, and they may have the votes to do it. Now, what happens if 230 is killed? I'm sure Baron and Megan will talk about that. But I want to just leave you with this thought. I'm almost out of time. Other countries in the world lack 230, right? We're not the only country in the world. Other countries lack 230. And, the internet hasn't fallen apart in those other countries. Now, it's very different. There's a lot of risks. But I don't take it anymore as a necessity that we're going to go with 230 forever. I think there's a very good chance that 230 goes. What it's replaced with, I don't know. On balance, I think 230 strikes a good balance, but it's not constitutionally required. I don't think, at least. I would hope it stays, but I think there might be enough political clout to kill it. Perhaps by executive action. I don't think that would work, but definitely by statute, I think it would. You're repealing one statute for another. All right, I think I'm out of time. I thank you so much. I look forward to what Megan and Baron have to say, and I appreciate your attention.
All right, thank you very much. That takes us to Megan Brown. Or sorry, that was Mr. Soka. You may now begin.
Thanks. So let me just set a few things straight so as we get started here. First of all, despite the title, this isn't just about big tech. Section 230 makes no distinctions about size of website. In fact, it applies to all interactive computer services. So that includes everything from the largest social media site and Google all the way down to the very smallest newspaper, which allows users to post comments on its website, your personal blog, your aunt's knitting blog, etc. And as Josh noted in passing, it equally protects the providers and users of social media, so and other interactive computer services. So your ability to reshare content, to retweet something, to forward emails, all of those things all of those actions are protected by Section 230. President Trump, for example, despite his almost incessant complaints about Section 230, invoked Section 230 to have a lawsuit against him dismissed based upon his retweeting allegedly defamatory material. That's just one example. The third thing I would clarify is that this debate becomes painfully confused because there are, in fact, two separate debates going on here. One of these debates is about liability for content that is hosted or made available by interactive computer services. So that's the debate about sex trafficking and gun sales and opioid sales and so on. That's not really what we're talking about today. This discussion today about free speech online is really a debate about content moderation, which is a broad term that includes removing content because it's objectionable, banning users, labeling content, putting other sorts of restrictions on users' ability to access content. It is often said that Section 230 enables content moderation, and in a practical sense, that's true. In both of the senses that we've been talking about that I just mentioned to you, Section 230 is very important as a mechanism to protect websites against the cost of having to litigate these cases on their merits. But in the two respects that I've just described Section 230 working, it works very differently. On the first debate, liability for third-party content, Section 230 changed the common law, and it changed it in the respect that Josh has just described. But I want to emphasize one thing he didn't mention. It's not critical to our debate about content moderation, but it is important to keep in mind generally. It is often said that Section 230 voided the 1995 Stratton-Oakmont versus Prodigy decision and instituted Cubby versus CompuServe as the law of the land, because of course in Cubby, CompuServe was found not to be liable. This really misunderstands Section 230, and it misunderstands what happened in Cubby. CompuServe was held not to be liable because it had no reason to have knowledge of the content at issue. But the court made very clear that under distributor liability, if CompuServe had done more to monitor content on its services, it would have been held liable. So what Section 230 really did was to void the Cubby rule to say that monitoring doesn't make you liable, and to void the Stratton-Oakmont rule, which is to say that content moderation wouldn't make you liable. And it's very clear that what Congress was trying to do in voiding those two cases was to supersede the common law and ensure that you would not be held liable for user content, regardless of any of these distinctions, regardless of whether a plaintiff called you a distributor or a publisher or a speaker of content. It wouldn't matter as long as you are an interactive computer service and you are not responsible in any way for the content that is at issue. So that's how Section 230 works on the liability for third-party content part of this debate. But the second misunderstanding that is often premised, upon which many of these conversations are premised, is, and you heard it at the outset here, that people read Section 230 and they assume that the text of Section 230, with its two or three, if you count them carefully, separate immunities, breaks down along the lines that I have just described. And that leads people to believe that Section 230C1, which says you're not liable as a publisher, protects you only for liability for the content that you host, and only Section 230C2A protects you for content moderation. If one reads any content moderation cases, one realizes very quickly that this is not the case. That Section 230C1, in its language saying that an interactive computer service provider may not be treated as the publisher of information provided by another, has been interpreted since 1997 consistently and broadly by every court that has heard these content moderation cases to include not only the decision to host third-party content, but also decisions to withdraw or remove or alter content that is provided by others, because these are all decisions that are made by publishers. The exercise of editorial discretion includes all of these functions. So the courts have held consistently and clearly that Section 230, C1, protects websites, interactive computer service providers, from liability as publishers in any of those actions. And what that means is that content moderation has been protected in nearly every single case by Section 230, C1. Now, the Trump administration argued that this indicated that the courts had gotten this wrong, that this violated the statutory canon of interpretation against surplusage, because it might seem to the uninformed person to render Section 230 C2A to be useless. But of course, that's not the case. Congress understood well what it was doing. And if one reads cases like, for example, Barnes versus Yahoo in the Ninth Circuit, the court explains very lucidly the work that Section 230 C2A does, which is it ensures that if a website is not protected by Section 230 C1, because, for example, it has some responsibility for creating the content. Suppose, for example, that it attempted to edit the content initially because it found it offensive, but that in turn made the website responsible for that content. C2A provides a belt and suspender protection. C2A does not work the way that C1 does. C1 relies upon the distinction between an interactive computer service provider and an information content provider, such that once you are responsible, even in part, for creating content, you lose your C1 protection. Section C2A does not work that way. Section C2A merely says that you are not responsible, not to be held liable for any content moderation decisions. So in that sense, C2A, as I say, is a belt and suspender provision, is a backstop, and it is clear evidence that Congress intended very clearly to protect content moderation from any form of liability. And the arguments that have been made by the Trump administration and other Republicans are simply mistaken. They simply do not understand how the courts have interpreted the statute or what the statute was intended to do. But they make a more deep mistake in reading the statute. They assume that it is because of Section 230 that websites are entitled to, as Professor Blackman put it, to remove content regardless of whether it is constitutionally protected. But of course, the First Amendment protects the right of private media operators to decide what content they will not host. This has been established in many cases, and I will talk about those in a moment, but all Section 230 does in both of the respects that we've talked about, C1 and C2A, is to provide a civil procedure shortcut to vindicate that right. It ensures that websites do not have to litigate these cases to completion in order to defend their First Amendment right to remove content. And how do we know they have this right to remove content? The Supreme Court has consistently held that that digital, social media, new media of whatever kind, are entitled to the same full protection of the First Amendment as other media. The court made this very clear in the Reno versus ACLU decision, 1998. Again, more recently in 2010, it's Justice Scalia who said that the protections of the First Amendment do not vary as new media arise. The one outstanding exception to this has been broadcasting. Broadcasting in 1969 was held to be a different medium, one that was merely affected by the First Amendment, but did not have full First Amendment rights. Why? Because the government owns the airwaves. The airwaves are scarce, and the Federal Communications Commission licenses broadcasters. It decides who gets to speak. That is state action, and that is state action that allows the government to regulate broadcast speech in ways that it could not regulate speech in other media. So, for example, in 1974, the Supreme Court, having upheld fairness doctrine mandates for broadcasters 5 years earlier in Red Lion, in 1974, the Supreme Court struck down fairness doctrine mandates, a mandated right of reply in Miami Herald versus Tornillo. And the court has made very clear since then that newspapers and digital media have the same First Amendment rights. So we know that we cannot impose fairness doctrine mandates, the right of reply, any impediment upon the decision not to host content of digital media, just as we know we could not do so for newspapers. Now, other arguments have been made. I don't have time to go through all of them, but I will just briefly summarize them. We've heard from the Trump administration that social media are public fora. They are equivalent to government actors, and therefore they do not have their own First Amendment rights. This argument patently misrepresents the Supreme Court's 2017 Packingham decision. Yes, Justice Kennedy, in passing, referred to social media as the new town square, but that case was about a state law restricting the access of convicted sex offenders to this new town square. That case tells us nothing at all about whether social media are public fora. And in fact, the court has more recently, in the Halleck decision, held very clearly that public fora are those very limited things like actual town squares that are unique government functions, historically provided only by the government. The court has not been willing to extend that to any other media. And in Halleck, the court specifically refused to extend that to cable providers who did something very similar to social media in hosting the speech of others in the form of public access channels. So Justice Kavanaugh very clearly said there that hosting third-party speech does not make you a public forum. Other courts have decided the same thing, Prager versus YouTube, for example, of the Ninth Circuit. So that argument is simple hogwash. There are other arguments that have been made more recently. I will just touch upon one of them in the interest of time, which is the idea that social media are common carriers. This argument misunderstands what common carriage is. Common carriage is not simply a decision that a certain service is important and that we must regulate it as such. It is, in nearly every case, it is a decision that reflects the nature of the offering. If one reads, for example, the cases that the FCC fought in the 1970s, NARUC 1 and 2 in 1976 at the DC Circuit, it becomes very clear that the essential characteristic of common carriage is the holding out to the public to serve everyone indifferently. So the phone company provides a service to everyone. You reasonably expect that your calls will be completed and the phone service will not edit the content of your communication. That's what a common carrier is. And when the FCC reclassified broadband providers as common carriers in 2015 in order to defend its net neutrality rules, and that was challenged in court at the DC Circuit, Justice Kavanaugh argued that this infringed upon the First Amendment rights of broadband providers because they had a right to determine what speech they would and would not carry, which of course is the opposite of what MAGA Republicans are arguing today. And the DC Circuit, the two judges who had upheld the order in the panel decision below, explained that the First Amendment was not implicated in that case because the nature of the offering was defined by the rules themselves. That is, that the FCC's rules had only ever applied to services that offered connectivity to substantially all endpoints of the internet. And as these two judges explained, that meant that a service that decided that it was going to make clear that it exercised editorial intervention, that it would not offer connectivity to all points on the internet, that it offered an edited service. So a broadband provider that, for example, said it would offer a family-friendly service plan, that broadband provider would not have been covered by the FCC's rules, and it could have opted out of common carriage because it would have changed the nature of the offering. Well, once you understand that, you understand very clearly that every social media service today is nothing like a common carrier. They all make clear that they exercise editorial intervention, as is their First Amendment right to do, as Justice Kavanaugh, then Judge Kavanaugh, was arguing. And they make that clear to their users. Now, you might say that it's not clear enough what they define to be hate speech or how they draw lines, but the fact of the matter is that they make clear that they exercise editorial control, and that makes them different from common carriers and broadband providers. And then the debate we are having is what the government can do about that exercise of editorial discretion. My opinion, in a nutshell, is nothing whatsoever. For the same reason that the government could not intervene and second guess the editorial discretion of Fox News or a newspaper or any other First Amendment protected medium. These are private decisions that are made by private actors. The government has no role here. Section 230 does not convert these into public fora, does not make them state actors. With respect to content moderation, it merely provides a civil procedure shortcut to ensure that with a motion to dismiss, these websites can avoid the great expense of litigation. So I will close by noting that there are many other theories that have been propounded, like public accommodations and so on. I can talk about those in questions if you like. But I will just close by noting why this is important and why it matters that we have Section 230, which is this. It is very simple and cheap and easy to file a complaint. One can do so without really making any legal arguments whatsoever. And without Section 230, many of those complaints would survive motions to dismiss. You would force a website to endure the cost of discovery and so on. Well, even filing a motion to dismiss has been estimated to cost something in the order of $25,000 to $80,000, to say nothing of the costs of discovery, which have been estimated to cost half on average of the cost of litigation, and in some cases 90%, to say nothing of the cost of a motion for summary judgment or trial. When one realizes the cost of what we're talking about here, the cost of litigation, one understands that the American legal system is quite different from legal systems in other countries. So the rest of the Commonwealth world, for example, doesn't have these problems in large degree because losers pay. It is difficult to certify classes. So Section 230 plays a really indispensable role in the American legal system because of the way that our litigation process works. And with respect to content moderation, it plays a vital role in ensuring that websites are not harassed by litigation and by the threat of what Judge Kaczynski once called death by 10,000 duck bites into surrendering their editorial discretion. And that is why Section 230 remains a vital protection for speech online and for websites to be able to exercise their right to decide what speech they will carry, which is the only right the First Amendment protects. It will not protect any user's right to force any private company to carry their speech under any circumstances.
All right, thank you very much. That leaves us to Ms. Brown. You may take your time.
Awesome. And I will not take my 15 minutes because you've heard a lot of very good legal and policy discussions thus far. I was just listening to Baron. It made me go to look at my phone to see which of the online functions, social media platforms, others that presently have the protections of 230 as a provider of interactive computer service that would potentially be rendered either uneconomical or in the crosshairs of litigants. And to put a fine point on it, from what Baron was saying, you know, if you haven't gone to law school and you haven't sort of been in private practice and in the legal world, it might sound very esoteric to talk about what lawsuits mean. But when you think about what a company would face, you know, you could name Yelp, TripAdvisor, Etsy, Grubhub, Instagram, many Facebook chat groups are the kinds of places that exist because of 230. Because what they've said is, as Professor Blackman said, and as Baron said, 230 is providing them both a sword and a shield, so they can get rid of content that they don't like, but that they're not obliged to get rid of unless some of the exceptions to 230 apply. So yes, all of these companies have or should have avenues to cooperate with the government to find child exploitation, right? Copyright violations. All of these companies have or should have ways to accommodate takedown requests. But what we're talking about is the ability of a lawyer to find a plaintiff to go and sue any of the companies that I just mentioned, Instagram, Grubhub, because someone doesn't like the stars that get applied to one of the companies that's available. I ordered my daughter dinner tonight on Uber Eats, and I looked at the ratings and I looked at the comments, and I promise you, in a world without 230, that function would be diminished, if not eliminated, because of the fear of liability that a company who works with Uber Eats or Grubhub or any number of these platforms would be annoyed by something they've seen there, right? And decide to sue the platform to say, you have allowed content that is harmful to me. Whether that's strictly under defamation or a business tort, that's, you know, for folks to debate. But the reality for that platform is likely to be they may face complaints to which they need to respond. They need to hire lawyers. They need to file a motion to dismiss. And as Baron said, you know, 25 grand is cheap. I look at some of the complaints that have been filed against Grindr, against Arms List, against any number of innovators or platforms, even people we don't particularly care for. And they would face an onslaught of complaints, and 230 protects them from that. It also enables them to get rid of stuff they don't like. If Facebook decides that it doesn't like a particular group or content being posted in a group because it's either climate denial or it's something that is problematic for public health in the COVID pandemic, it can take it down. And as Barron explained, it's a private company. It's not a state actor. And so it has that First Amendment right to do so. And what 230 did for practical purposes was recognize that the onslaught of litigation over those decisions or over the hosting of content was a real threat to the exercise of that First Amendment right. And so 230, from my perspective, as a practical matter, is sort of a bubble around a lot of the expression that is already protected by the First Amendment. If you took away 230, it's entirely possible that after years of protracted and expensive litigation, you would vindicate the First Amendment right of an Instagram to either host or take down content. But the writers of 230, who are still alive and make this very clear, their goal was to insulate from that litigation, from that chilling effect, that kind of First Amendment activity, because they thought that would, catalyze a robust online environment. And you know what? They were right. So when Dylan sent around questions to us to sort of tee up what this debate really is about, and Barron's totally right, there are many little subplots and confusing doctrinal areas that are going on. But at its core, what it seems to me to be about recently is, should content moderation, right? Should Facebook banning Trump or Twitter banning Trump mean that they give up the protections of 230? And now they're subject to suit for either hosting content that anyone may find objectionable, or for taking down content that they find objectionable. And I think it really only becomes practical and understandable when you take it away from the Twitters and the Facebooks and the giant so-called tech companies, and you make it real, right? An Etsy seller is using a platform that exists because they make functionality and communication available. And if you were to subject Etsy or its vendors to the threat of lawsuit because someone writes in and says, you know what, that coaster set you made me sucked and I hated it and it was stupid and you're not a good manufacturer. If that could generate litigation, that is a troubling place for the proliferation of online commerce and the exchange of information. And so to me, that's what's at risk when we talk about gutting Section 230, and why I don't like the idea that government is going to try and bully private companies into either receding from their content moderation rights or being more aggressive in what they take down and what they scrutinize. These are fundamentally private platforms. And so I echo what Barron said about the common carriage issue. You know, one of the things Dylan asked us to look at is what would be alternatives, sort of what our reactions were to reforming Section 230 to treat social media companies as publishers. And second, what do we think of turning social media platforms into common carriers? And in brief, the first idea is a bad idea. It will distort the free flow of information on the internet and the proliferation of this amazing innovation economy that is very distinct from our global peers. Other countries don't have our tech base and our innovation economy, in part, I would say, because they don't have this bubble of protection around companies. Now, Barron's right. They also don't have our civil litigation problem that I think we have, but that's why 230 exists, is to insulate them from that. On the common carriage point, you know, as a telecom lawyer, I think that's not the right approach. Barron summed up a lot of the legal issues there and some of the case law reasons why it's a bad idea, but being very practical for those who aren't lawyers. When you're a common carrier, a lot of regulations attend that. And so for years, folks have understood that there are massive public interest benefits to treating services not as common carriage, because a lot of baggage goes with a common carrier designation. Second, you know, these social media companies, it's easy to talk about them in this sort of abstract way, but there are definitional questions there that would be very difficult. Who counts as a social media company? Barron's right. It's not just the big guys. It'll be a lot of small people. And then quite frankly, who in the government would have the institutional competence to create content guidelines for these common carriers? Not, forgetting, of course, that common carriers today are not regulated for content in that way. So, from my perspective, the debate here gets muddied by a lot of legalisms, but it really boils down to, do we want a world in which folks can sort of sue and attack a lot of the innovators who have driven much of the economic benefits of the last 15 to 20 years? Or do we want to sort of make it a giant payday for a lot of the lawyers in this country who will relish suing both small and large companies to extract settlements from them? Dylan, you had asked a couple of questions about litigation and national security, but we're running late on time. So why don't we open it up to either you or folks who are dialing in?
Great, yes, thank you. So at this time, if anyone in the audience does have questions, you can feel free to click the Q&A button that should be at the bottom of your screen. And you may also raise your hand to ask a question in person with the video. In the meantime, I have a few questions of my own that I'd love to ask the panel just to clarify some of the issues. So this panel has rightly emphasized the reach of Section 230 beyond just these handful of social media giants. However, many Americans, including the former president, are concerned with this handful of companies that host and moderate massive amounts of online speech. So while Twitter, Facebook are not at all in a technical sense monopolies, it may be argued that if we continue on our current course, at some future point, there could be no reasonable alternative to engaging with modern social life. For instance, I don't like to use Facebook, but I had no other option but to promote this event on Facebook to reach the people in the audience. So if these tech companies continue to grow in their influence and reach, should the government at some point, hypothetically, play a larger role in regulating content if they get large enough?
I'll go first if I can. I've been quiet for a bit. One possible alternative that I've seen was from Senator Josh Hawley, who I'm sure is Barron's arch nemesis or something like that. I can see him getting angry. And Senator Hawley would have only applied the sort of Section 230 repeal to bigger tech companies. In other words, only tech companies with more than X number of users, which would, let me just get it, is more than 30 million active users. So it basically would only apply to, Facebook, Twitter, Instagram, and maybe a couple others. So smaller companies that aren't so ginormous wouldn't have their liability taken away. So maybe that's one possible option. I think another way to look at this question is, what does free speech even mean? Barron mentioned that the Miami Herald case where the court says, if someone writes a damaging newspaper editorial about you, do you get a right to reply in that newspaper? Well, maybe if you don't reply in that newspaper, you reply in another newspaper, a third newspaper, right? Perhaps critics of Section 230 argue that there is no alternative to Facebook and Twitter. You can have your own blog, perhaps if Google de-indexes you, no one can ever find it. So is there still an outlet? Now, I don't think repealing 230 would make things better. I think it would actually make things significantly worse. But I think we can at least acknowledge, for argument's sake, that the free speech dynamics perhaps were different today than they were 30 years ago.
So I'd love to respond to that. I'm going to read you a short quote, and we'll play guess which Supreme Court decision that came from. Quote, "The result of these vast changes has been to place in a few hands the power to inform the American people and shape public opinion. The abuses of bias and manipulative reportage are likewise said to be the result of vast accumulations of unreviewable power in the modern media empires. The First Amendment interest of the public in being informed is said to be in peril because the marketplace of ideas is today a monopoly controlled by the owners of the market." Any guesses which decision that came from?
I'm guessing it's an old one.
I think it's New York Times.
It's Miami Herald.
Yeah.
The argument in Miami Herald was newspapers have local monopolies. They're the only game in town. literally literal monopolies, that the entire media ecosystem for a particular area was controlled by only one company. And the Supreme Court said, doesn't matter. It doesn't change the First Amendment analysis. Just to finish the point. So there is one case, there's one Supreme Court case where that maybe mattered, which is Turner. So if you're familiar with cable and broadcasting regulation, you may know that the most controversial issue regularly is that in 1992, Congress, the 1992 Cable Act, gave local broadcasters the right to force cable companies to carry their channel, the must carry right. The broadcasters exercised that right. The cable companies appealed. And in the Turner decision in 1994 and 1997, the Supreme Court upheld must carry. And they did so on grounds that sound a lot like what we're talking about here today. They wanted to promote the diversity of the media ecosystem and defend local broadcasters. And you might think that sounds a lot like defending Parler or whatever, right? Well, if you read Turner carefully, it becomes very, very clear very quickly how radically different that case was. Because that case, first and foremost, the only reason that the gatekeeper so-called power of cable providers mattered is that the court was applying intermediate scrutiny, not strict scrutiny. And why? Because the court held that there was no evidence that these that the regulations were in any way motivated by a desire to respond to or counterbalance the editorial choices made by cable providers. Well, that's obviously what's happening here. The Republican Party has decided that it needs to counterbalance the choices that are being made by the gatekeepers, and they're pushing an agenda to get their speech carried. It's obviously different from Turner. And moreover, in Turner, the only infringement upon editorial discretion was that cable providers were denied the right to put together the most profitable programming packages. And the court went out of its way to note in upholding the rules that the cable providers never objected to any of the content they were being asked to carry, which isn't surprising because it was broadcast content, which was heavily sanitized and regulated by the FCC. They were not being forced to carry neo-Nazi content or white supremacism or incitement to violence or the kind of content that led to the death of 5 Americans on January 6th. That case is manifestly different, and it makes very clear that when social media refused to carry that kind of content, that's a kind of editorial discretion that the court will absolutely protect, and no amount of hand-wringing about the limited number of options will change that analysis. Megan, please.
I think, from my perspective, though, I think I get all of that. I think the difficulty in this discussion is that you end up with these sort of poles of, if you, on one side, you want to protect the January 6th insurrection content. And on the other, you want to strip these social media companies of all their rights. And I think reasonable people can agree that or can take the view that deplatforming as a concept is problematic, totally separate from Trump, right? Like the idea that it might be very difficult for certain economic interests or otherwise to have YouTube platforms, et cetera. So I get where Josh is going with that this idea of gatekeeper control is unsettling to many. And I think that's what Dylan was trying to sort of tease out, is that the gatekeeper idea is unsettling to a lot of people who feel like they're going to be marginalized or excluded from that. I think the key problem, though, or the key challenge for both policymakers and legal folks, but also Americans who are thinking about this, is what does it mean to be a gatekeeper? And when you say for instance, when you say, Dylan, you had no choice but to advertise on Facebook, maybe you felt that as a practical matter, but is that really true? And empirically, I'm not so sure that that's really true in the sort of traditional antitrust approach that one would say, oh, you are a monopoly in the way that the railroads were back in 1890, therefore we need common carrier regulation to force upon you a non-discrimination approach and a non-self-dealing approach and a requirement to take all comers. And that's just a very different thing than I think we're dealing with now, even though I can be very troubled by some content moderation decisions that I see. And I think if you're looking for creative solutions to that, I would urge policymakers not to try and, gut 230 or try and make content moderation this kind of, Sophie's choice. Like, if you content moderate in any way that we don't like, we will then take away your 230 immunities, does not seem like a great way to sort of structure the freedoms of the internet. I think there may be other ways to examine that, whether that is congressional oversight, like we are seeing. I wish that was a bit more nuanced than it is, or whether that is Federal Trade Commission examination of big picture issues. But I don't think it is, let's go gut 230, or let's threaten 230 immunities as the cudgel that we will use to force you to either engage in content moderation that we like, right? Go strip certain objectionable content, or walk away from content moderation completely. And that's sort of how I think of this, with that lens of, because what you're doing is you're throwing these people, these companies, these platforms, small folks, not just the big guys, to the wolves of litigation. And I don't think that's the way we should be regulating the internet, if you want to call it that.
Great, thank you for those responses. We have a question from the audience from Anson Fung. Anson, I'm going to allow you to talk and see if this works.
And you're being recorded, Anson, just so you know.
All right, sounds good. Thanks, y'all. And just before I ask my question, I just want to say, Josh, it's good to see you again. I was at your talk on corpus linguistics a few weeks ago at the University of Chicago. So,
so good to see you.
One Rice alumni, very glad to see the Federalist Society still going strong here at Rice. Nice job, Dylan. So my question is about the ex ante effect, perhaps, of weakening or removing Section 230 protections. It would seem to me that, I don't know, the increased liability would hit, say, small players in the market or newcomers to the market significantly. Do you? I guess this is just a general question to the panel, whether you anticipate that kind of effect if we, say, weaken or turn Section 230 into a more standards-based approach. Thanks.
I mean, I'll just throw in one perspective from the counseling that I do for clients, which sometimes looks at, will 230 protect some of your decisions? And I think you can achieve through contract a lot of the protections of 230, which is, you can say to consumers, we can take your stuff down, we can, you have no rights to sue us for X, Y, or Z. I just think when you bury all of that into terms of service, end of user, end use licensing agreements, you still have the threat of litigation. So to me, 230 is a very important tool in the arsenal of a private company. And yes, I think you're right, Anson, the smaller companies are going to be less able to withstand any of the complaints that will have the multi-million-dollar threats against it. I don't mean to concede that the large companies will just be able to absorb this. Many people think, oh, litigation is just a cost and the big companies can handle that. Some of these threats are really existential if you're talking about small decisions over large user bases. But I think you're onto something, that smaller companies may find this just unacceptable as a risk and not have, for example, a comment function at all, not take user input, for example. And that would be harmful to many of the services that, I think all of us use. TripAdvisor, for example, would be one example. So I think you're onto something there with the disparate impact.
And if I may add to that, the problem of scale is not just the problem that Facebook faces. It's not just the problem that you have, a billion users. The problem of scale exists as soon as you have any website at all. I mean, this problem existed back in 1994. It was impractical at the time to have to moderate every single piece of content or face liability from it. I mean, it's just categorically different from the task that a traditional publisher faces in screening letters to the editor, where they can pre-review things and have staff look at them and so on. So it's both a problem of scale and of time. The interactive real-time internet would be impossible at any scale without the protections of Section 230.
Any thoughts, Professor Blackman?
No, I think they know more about markets than I do, but I appreciate the question. Thanks, Aaron.
I have a question for the panel as well. Mr. Soka said that Section 230 provides a civil procedure shortcut to the legal issue. If Section 230 were repealed, there would doubtless be mountains of very costly litigation. It may have a chilling effect, as Megan suggested. But at the end of the day, after all the lawsuits, would the First Amendment be interpreted to have the same functional effect of Section 230 to allow web platforms broad discretion to host and moderate content?
Yes, that is the essence of my remarks. To respond for a moment to what Megan just said, I think one needs to distinguish between levels in thinking about what is problematic. You may find it problematic that power is concentrated, that decisions are made that you don't like or whatever. That doesn't mean it's a constitutional problem. And the First Amendment leaves everyone unhappy. But that's the whole point of the First Amendment, is to tell people no. So my answer is the First Amendment bars the government from intruding upon decisions to refuse to carry content, period. And that includes harassment through congressional hearings. It includes attempts to use consumer protection law to second guess how websites make decisions over carrying content. Antitrust law, of course, can be used against media companies insofar as they are exercising economic power to make economic decisions, but not for the exercise of editorial discretion. That is something the First Amendment protects. And I will just remind everyone that in 2004, when the FTC was asked to bring a consumer protection action against Fox News for not really being fair and balanced and for deceiving its users, the Republican chairman at the time simply said that we cannot do this without evaluating the content at issue. And that is a task that the First Amendment leaves to the American people, not the government. And I say the same thing categorically about all content moderation decisions. It is something that Section 230 merely allows. Section 230 is not a sword given to private websites. The sword is the First Amendment. Section 230 is merely the procedural protection that allows them to avoid the expense of litigation over these issues.
And let's be clear, the expense of that litigation is often quite robust, because in litigation between private parties, invocation of the First Amendment is very difficult. And you can be stuck in, you could just look at the discovery issues, the New York Attorney General's war on oil and gas, right, for their advocacy on various climate change issues. Those companies were basically unable to get their First Amendment defenses heard because they were stuck in this protracted discovery. And so it's a real problem. And I think that's why 230 exists, is to try and insulate and not make everybody fight those fights for 5 years and untold millions, while there's a chilling effect while they fight.
And let me raise another issue, just food for thought. We've been talking so far about stuff that's posted, right? If I post something on Twitter or Facebook, what about a social media company's own speech? For example, Google, right? If I go to Google and I type in a search for Rice Federalist Society chapter, Google spits some results out. Are those results speech? Is that some sort of automated content? Is that entitled to First Amendment protection? Can the government regulate search algorithms, right? We're not just talking about tweets. So the sorts of arguments that Barron's talking about here about the First Amendment, it goes broader, right? Search engines, are they engaging in some sort of editorial content like Fox News of what they want to put on the air? Are they sort of dumb, passive algorithms that just spit out whatever? If a Google search result is editorial content, like, oh, we want to put this result first and this thing second, this one third, then maybe it's in the same position as a newspaper, or in the same position as maybe a cable news network. If this is something that's not, then First Amendment issue gets tricky. But trust me, the people want to regulate are not going to stop at Twitter and Facebook. They want to go after Google as well.
As a follow-up to Megan and Professor Blackman, over time, if 230 were repealed, as clearer case law is established, would the cost and amount of litigation decrease, or would this be a continuing issue into the foreseeable future?
I mean, I tend to think it would be a continuing issue, because just let's say the perfect case came up, the most aggressive complaint, sort of, that could run its way through the courts for years. In the meantime, you're dealing with the chilling effect on others who are not resourced to fight that litigation. Then in your hypothetical where, let's say, the Supreme Court, maybe after 10 years, right, they would let it percolate for a long time. And then let's say they say definitively after 10 years, the First Amendment protects X. Well, then you'd have a whole nother set of issues defining what is and is not X. And so I'm just highly skeptical that you can rely on our court system, which is neither speedy nor really well suited to make these policy determinations, right? If a company wants, you're a new entrant, and we get asked this question. Let's say I'm hosting I'm a cloud service provider, and I want to host this business, and I don't want to do know your customer, and I don't want to try and figure out who all the users are of my cloud service, but am I going to be sued down the road for some horrible crap that gets stored on my cloud? Well, right now 230 protects you. If you're an entrant who's debating a new offering, while that Supreme Court stuff plays out for 10 years, are you going to take that risk? Probably not. And that's going to stultify innovation. And so the answer to your question is no, I don't think it ever really goes away. It's just going to be a machine of litigation that will be like a perpetual motion machine of constantly drilling down on how to go at these companies to seek a settlement or a payday. And you'll have bad precedent created by settlement as well, because very few companies are going to go to the Supreme Court on their issue.
Megan put that extremely well. I would only add that to that problem of the weaponization of civil litigation, you have political motives. And we already know that this will be weaponized to retaliate against speech. So the concept that I would give to you is that we know what strategic lawsuits against public participation are. You write a review of your dentist, or you say something about a public figure and you get sued for it. States have passed laws that allow you to quickly dismiss those suits under their anti-SLAPP laws. What I am concerned about, what will happen, what Republicans have already been trying to do, is the weaponization of strategic lawsuits against moderation. They will file these lawsuits, however frivolous, repeatedly, again and again and again, against all providers, to harass them and to coerce them through inflicting cost upon them in highly asymmetrical warfare, where filing the suit is very cheap and it carries no consequences. We don't live in a loser pays country, so why not try? The cost of defense is many, many times greater than that. And that becomes a tool to coerce websites into carrying content that they do not want to carry. So in the end, for me, the real irony here is what this amounts to is Republicans having spent 70 years arguing against the fairness doctrine for broadcasting, which was probably unconstitutional. And if it was constitutional, it was only constitutional because broadcasters didn't have full First Amendment rights, are now, led by Josh Hawley, arguing for what amounts to a more aggressive, turbocharged, more arbitrary, more politicized fairness doctrine for the internet without any hint of irony.
And if I could just throw in, I don't know if Professor Blackman wants to also weigh in here. One place where I part company with Barron is I don't see this as such a partisan issue. I think it is partisan right now in certain respects, but the dangers here are from sort of all sides. If it's open season in providers of interactive computer service, you will see anyone, sort of regardless of politics, jumping in, I think, to try and have a payday or advance their agenda, whatever that political agenda may be or ideological agenda to go at it. So I think it's not as helpful to frame it as a Josh Hawley issue as it is to say like it's a structural problem that will allow all comers to try and bludgeon ICS of any variety into submission with their views.
In the future, we will all be canceled. Just everyone will be canceled. There'll be nothing left. We'll just be massive cancellations.
It's a good expert take, Professor Blackman.
I tried. I did.
Yes.
I think that was a compliment. I'm not sure.
No, it was a good. And it takes us to another question from Anson. I believe you may unmute yourself.
Yep, I got the unmute button right now. Just a general question to the panel about the applicability, perhaps, or what you guys think the applicability of Section 230 would be to, say, decentralized content hosting platforms. So right now we've been talking a lot about server side, client side, whereas, say, you know, I don't know, say a blockchain based service, how 230 might apply to that.
That's a question for Baron, I think.
It's actually a great question. So I'll just start by answering that with respect to Wikipedia. So Wikipedia is the first service that would die without Section 230, because not merely because Wikipedia is a nonprofit and doesn't have the kind of legal resources to defend itself that big tech companies do, and not merely because it's highly politicized and it's subject to wars over editing content, but because the users, the moderators themselves, would be subject to suit. And Section 230 provides them, because remember, it applies to both the provider and user of interactive computer services. So the kind of thing that you're hypothesizing, which I love, is something that would only be possible in a world with Section 230's current protections, both for the hosting of content and also the removal of content. And to your earlier question, you actually used a really important term. You said, what would happen if we move to a standards-based approach to Section 230? Well, what would happen is Section 230 wouldn't work. Section 230 works today precisely because it is not standards-based. That is to say, when you are sued, you don't have to say, oh, Your Honor, I satisfy this standard of reasonableness. And the judge would say, well, that's a question of fact, so let's have discovery and come back to me after the other side has gotten its evidence, and then we'll see what we think about that. Right? That is many times more expensive, if not orders of magnitude more expensive, than being able to resolve on a motion to dismiss on the simple fact that you are an interactive computer service provider. The lawsuit seeks to hold you liable for the content that is created by another, and then you win your suit. Right? That's how Section 230 works today. If you change that, you break Section 230, and with it, you make services like the one that you're describing impossible, because in principle, any user who hosts any part of that service could be liable. And that obviously would have an enormously chilling effect upon the willingness of users to participate.
I think we're out of time. We're just about
out of time. If anyone has any last questions, feel free to raise your hand or ask that in the chat. If not, I suppose I'll just ask one final question. You are all legal experts. We brought you here to talk about the law. I'd like you to put on your political analyst hats. How likely do you think it is that Section 230 is significantly altered by this Congress? Will you, the lawyers, win out over the politicians? Start with Professor Blackman.
I put it greater than 50%. I think it's greater than 50%.
Any other thoughts?
Well, remember, there are two different debates happening here, and that's what it gets so confusing. So what Megan just described when she described the attack on 230 from all sides is quite true with respect to Section 230's protection against liability for content that one hosts. That is a subject of bipartisan attack. There are multiple bills out there, and something will change. And by the way, I'm not against all of those things. I think, for example, that if you get a court order that is valid, that requires you to take down certain content, I could live with a system that properly channels notification to do that. So in that respect, yes, I think Section 230 may change. It's not immutable. But with respect to content moderation, again, there's nothing to change. What Section 230 does is merely protect First Amendment rights, and any attempt to change that, in fact, in my view, imposes what amounts to an unconstitutional condition. It would force Josh Hawley's bill, for example, that Professor Blackman referenced. That bill, yes, it purports to limit its application to large websites, but what it really does is create a licensing system so that the Federal Trade Commission would decide every 2 years whether you had been fair and politically neutral. And if you hadn't, if even two commissioners, that is, even the minority party out of power, could deny you your recertification, which would be equivalent to the FCC taking away your broadcast license, right? That is literally what the fairness doctrine did at the FCC, which Republicans fought and fought and fought, and is still in the Republican platform as being a terrible, terrible thing. So, in that respect, I don't think anything's likely to happen, but I think that Republicans, now that they've decided that they're the victims of this, that they will completely continue to attack Section 230 and claim that it is the problem and pretend that they haven't completely switched sides on the question of the fairness doctrine and the First Amendment.
All right, and Megan, last word.
I'm going to take a pass on prognostication. I do think there's a lot of folks who, of all different stripes, who have problems with 230. I think there's a lot of misunderstanding of 230. And so I don't know that I'm with Josh on above 50%, but I think 230 has some real challenges facing it. And the folks who love 230 need to really continue to defend it. Yeah, I'm worried.
All right. Well, thank you once again to our panelists. I, for one, found that incredibly informative and productive to this national conversation that we're having right now. Thank you once again to all of our attendees for showing up. I hope you enjoyed that event as much as I did. With that, if you are interested in keeping in touch with Rice Federalist Society events, feel free to join it. Keep track of our listserv, keep track of our Instagram account. We'll be posting events there. And of course, our Facebook accounts, which hopefully will be able to stay in effect. So thank you all once again for coming. I am going to go ahead and close this meeting. Our panelists, once again, I cannot thank you enough for making this event possible. Thank you all.